Are you an employer? What do you need to know about employment contracts? Hi, I'm Simon Dippenaar and I'm an attorney. A complex framework of legislation governs employment relationships in South Africa, including the Labour Relations Act, the LRA, Basic Conditions of Employment Act, the BCEA, and the Employment Equity Act, EEA. This framework establishes the minimum standards for employment and provides appropriate mechanisms to resolve disputes between employers and employees. If you understand how to structure employment contracts and handle potential labour disputes, you'll be more likely to maintain good labour relations. A well-drafted employment contract establishes the rights and obligations of both parties and can significantly impact how disputes are resolved. An effective employment contract should contain a clear description of the employee's position, responsibilities and performance expectations, details regarding salary, bonuses, commission structures and other benefits, working hours, overtime policies, leave entitlements and workplace conditions, duration of the employment, whether the position is permanent or fixed term, duration, assessment, criteria and notice requirements of any probatory periods, grounds for termination, notice periods and procedures for termination by either party, confidentiality and restraint of trade provisions, if applicable. In other words, the period of time before the employee can be engaged by a competitor. If a contract is unclear or incomplete, disputes are more likely to happen. The contract should not contain vague or ambiguous terms. Where terms have more than one meaning, clarification within the contracts will avoid conflicts. Any provisions that contravene minimum standards established by labour legislation, outdated information. If an employee is promoted or changes roles, the contract should be promptly updated. Overly restrictive restraint of trade clauses. In other words, any provisions should not reasonably limit an employee's future employment opportunities. But despite a well-drafted contract, labour disputes are sometimes unavoidable. When they arise, you need to have a thorough understanding of legal procedures. Professional legal advice is also strongly advised. Labour disputes mostly fall into one of the following categories. Unfair dismissal. This is the most common dispute which arises when an employee alleges termination was substantively or procedurally unfair. Unfair labour practices. This includes unfair conduct related to promotion, demotion, probation, training or benefits. Discrimination. An employee may allege unfair discrimination based on race, gender, age, disability or other protected grounds. Wage and benefit disputes. Disagreements may occur over compensation, overtime, leave pay or other financial settlements or entitlements. In a small business, it is easier to prevent disputes through regular communication. But whether the company is large or small, certain organizational behaviors will reduce the potential for labor disputes. Clear documentation and accurate record keeping are critical. Maintain detailed records of all employment-related matters, including performance reviews, disciplinary actions, and attendance records. Apply workplace policies consistently across all employees to avoid claims of discrimination. Periodically review company policies to ensure compliance with evolving labor legislation. Establish mechanisms for employees to raise concerns before they escalate into formal disputes. Ensure managers understand labor law basics and proper procedures for handling disciplinary matters. Unfair dismissal claims are a common cause of labor disputes, so I'm going to spend a few moments on this. You should be familiar with the LRA's 3 recognized grounds for dismissal: misconduct, incapacity, and operational requirements. Regardless of the grounds, dismissals must be both substantively and procedurally fair. Substantive fairness refers to the valid reason for dismissal. There are 3 reasons you might dismiss an employee. Misconduct. You must prove the employee violated a reasonable workplace rule or duty despite understanding that rule or duty and the obligation to fulfill it. Poor performance. You must demonstrate reasonable performance standards were not met despite adequate support and opportunity to improve. Operational requirements. You must show that genuine business needs prompted the dismissal. Even with justifiable grounds for dismissal, you have to follow correct procedures. Carry out a thorough investigation into alleged misconduct or performance issues. Provide the employees with notice of allegations and sufficient time to prepare a response. Conduct an impartial disciplinary hearing where the employees can present their case. Dismissal should be the last resort. Before you reach that stage, alternatives such as warnings, trainings, or reassignment should be considered. The employee also has a right to appeal, and the appropriate mechanism for an internal appeal for disciplinary decisions should be available. If internal dispute resolution mechanisms fail, South Africa's labour law provides several alternatives. The Commission for Conciliation, Mediation and Arbitration, CCMA, is often the first forum for resolving labour disputes. This process involves conciliation, which is an attempt to resolve the dispute through facilitated discussion. If this fails, an arbitrator hears evidence and makes a binding decision. CCMA proceedings are more informal than court proceedings, but arbitration awards are legally binding and can be made an order of court for enforcement purposes. More complex disputes may proceed to the labour court. Compliance with South African labour law requires careful attention to both employment contracts and dispute resolution procedures. If you need help to comply with the current legislation or to develop labour relations strategies that address your particular circumstances and challenges, get in touch with me or my team on the number below.